Narciso filed a complaint against Northern University for the payment of retirement benefits after having been a part-time professional lecturer in the same school since 1974. Narciso taught for 2 semesters and a summer term for the school year 1975, took a leave of absence from 1975 to 1977, and resumed teaching until 2003. Since then, his contract has been renewed at the start of every semester and summer until November 2005, when he was told that he could no longer teach because he was already 75 years old. Norte University also denied Narciso's claim for retirement benefits, stating that only full-time permanent faculty who have served for at least 5 years immediately preceding the termination of their employment can avail themselves of post-employment benefits. As part-time faculty member, Narciso did not acquire permanent employment status under the Manual of Regulations for Private Schools in relations to the Labor Code, regardless of his length of service. Is Narciso entitled to retirement benefits? Suggested answer, yes. Narciso is entitled to retirement benefits. A part-time lecturer with a fixed-term employment who did not attain permanent status is entitled to retirement pay. This was ruled by the Supreme Court in De La Salle, Araneta University versus Bernardo, GR 190809, February 13, 2017, as follows. Republic Act 7641 states that any employee may be retired upon reaching the retirement age, and in case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements. The implementing rules provide that Republic Act No. 7641 applies to all employees in the private sector, regardless of their position, designation, or status, and irrespective of the method by which their wages are paid, except to those specifically exempted. And Secretary Kizumbing's Labor Advisory further clarifies that employees covered by Republic Act No. 7641 shall include part-time employees, employees of service and other job contractors, and domestic helpers, or persons in the personal service of another. Note: the foregoing answer can be found in pages 921 to 924 of the book entitled Principles and Cases Labor Relations, 2nd edition 2018 by attorney Voltaire Duano. This was the first time that this question was asked in the bar examinations. Letter B. If he is entitled to retirement benefits, how should retirement pay be computed in the absence of any contract between him and Norte University providing for such benefits? Suggested answer. The retirement will be 22.5 days salary, exclusive of leave conversion benefits. According to Capital Wireless, Incorporated versus Honorable Secretary Nieves Confessor, GR 117174, November 13, 1996, for purposes of computing compulsory and optional retirement benefits and to align the current retirement plan with the minimum standards of Article 287 of the Labor Code, as amended by RA 7641 and Section 5.2 of its implementing rules. 1/2 month salary means 22.5 days salary exclusive of leave conversion benefits. Unless the parties provide for broader inclusions, the term 1/2 month salary shall mean 15 days plus 1/12 of the 13-month pay and the cash equivalent of not more than 5 days of service incentive leaves. Note: the foregoing answers can be found in pages 924 to 925 of the same book. Ngayon Federation issued a charter certificate creating a rank-and-file Newman Employees Union. On the same day, Newman employees filed a petition for certification election with the Department of Labor and Employment Regional Office attaching the appropriate charter certificate. Letter A. The employer, Newman Corporation, filed a motion to dismiss the petition for lack of legal personality on the part of the petitioner union. Should the motion be granted? Suggested answer. The motion should be denied. For purposes of filing a petition for certification election, Newman Employees has legal personality from the time it was issued with the charter certificate. This is clear under the Labor Code, which provides the chapter shall acquire legal personality only for purposes of filing a petition for certification election from the date it was issued, a charter certificate, Article 241-234-A, as inserted by Section 2 Republic Act of 9481, which lapsed into law on May 25, 2007, and became effective on June 14, 2017. Letter B. The employer likewise filed a petition for cancellation of union registration against New Newman Employees Union, alleging that Nayon Federation already had a chartered local rank and file union. Newman Employees Union pertaining to the same bargaining unit within the establishment. Should the petition for cancellation prosper? Answer. Under Article 247 of the Labor Code, the following are the relevant grounds for cancellation of union registration. A. Misrepresentation, false statement, or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto. The minutes of ratification and the list of members who took part in the ratification. Letter B. Misrepresentation, false statements of fraud in connection with the election or officers. Minutes of the election or officers and the list of voters. Letter C. Voluntary dissolution by the members. Unless the employer can prove that any of the foregoing grounds are present, the petition for cancellation will not prosper. Note: the foregoing answer can be found on page 223 of the book entitled Principles in Cases, Labor Relations. Second edition, 2018, by the same author, Attorney Voltaire Duano. Due to his employee's dire financial situation, Nicanor was prevailed upon his employer to voluntarily sign. In exchange, he demanded payment of salary differentials, 13-month pay, and financial assistance as promised by his employer. Management promised to pay him as soon as it is able to pay off all retrenched rank-and-file employees. 5 years later, and before management was able to pay Nicanor the amount promised to him, Nicanor died of a heart attack. His widow, Nori, filed a money claim against the company before the National Labor Relations Commission, including interest on the amount of the unpaid claim. She also claimed additional damages, arguing that the supposed resignation letter was obtained from her spouse through undue pressure and influence. The employer filed a motion to dismiss on the ground that A. the NLRC did not have jurisdiction over money claims, and B. the action has prescribed. Does the NLRC have jurisdiction toward money claims, including interest and the amount unpaid? Suggested answer. Jurisdiction will depend on the amount being claimed by Nicanor's surviving spouse. If the amount exceeds 5,000 pesos as provided in Article 224, letter A, number 6 of the Labor Code, then jurisdiction belongs to the arbitration branch of the NLRC. However, if the amount did not exceed 5,000 pesos, and then jurisdiction belongs to the regional director under Article 129 of the Labor Code. Involving recovery of wages, simple money claims, and other benefits, either of the said quasi-judicial body can award interest in the concept of actual and compensatory damages in accordance. The award of interest in money claim was explained in Lingan versus Asian Institute Management, GR 220481, February 17, 2016, that the rate of interest in the concept of actual and compensatory damages as well as its accrual are as follows. When the obligation is breached and it consists in the payment of a sum of money, example, a loan or forbearance of money, the interest due should be that which may have been stipulated in writing. Furthermore, the interest due shall itself earn legal interest from the time it is judicially demanded. In the absence of stipulation, the rate of interest shall be 6% per annum, to be computed from default, from judicial or extrajudicial demand, under and subject to the provisions of Article 1169 of the Civil Code. Number 2. When an obligation not constituting a loan or forbearance of money is breached, an interest on the amount of damages awarded may be imposed at the discretion of the court at the rate of 6% per annum. No interest, however, shall be adjudged on unliquidated claims or damages, except when or until the demand can be established with reasonable certainty. Accordingly, where the demand is established with reasonable certainty, the interest shall begin to run from the time the claim is made judicially or extrajudicially, Article 1169 of the Civil Code. But when such certainty cannot be so reasonably established at the time the demand is made, the interest shall begin to run only from the date the judgment of the court is made, at which time the quantification of damages may be deemed to have been reasonably ascertained. The actual base for the computation of legal interest shall in any case be on the amount finally adjudged. Number 3. When the judgment of the court awarding a sum of money becomes final and executory, the rate of legal interest, whether the case falls under paragraph 1 or paragraph 2 above, shall be 6% per annum from such finality until its satisfaction. This interim period being deemed to be by then an equivalent to a forbearance of credit. The answer can be found in page 26 of the book of Attorney Duano. Letter B. Assuming that the NLRC has jurisdiction, has the action prescribed? Answer. The action has not prescribed. This is because Nicanor's surviving spouse cause of action will accrue upon the categorical denial of the claim. In this case, there was demand for its payment. However, the management had promised to pay as soon as it is able to pay off all retrenched rank-and-file employees. However, it was only after 5 years that the management was able to pay. Moreover, there was no denial of the claim. Therefore, prescription did not set in. In the Degamo versus Avant-Garde Shipping Corporation, GR 154460, November 22, 2005, and Serrano versus Court of Appeals. Following cases, the Supreme Court explained the accrual of a cause of action under Article 306. May Nicanor's spouse successfully claim additional damages as a result of the alleged undue pressure and influence? Yes, Nicanor's spouse can successfully claim additional damages as a result of the alleged undue pressure and influence. This is provided under Article 224, letter A, number 4 of the Labor Code, which provides for claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relationship within the jurisdictional authority of the arbitration branch of the NLRC. In the alternative, it cannot be argued that Nicanor's spouse cannot successfully claim additional damages because it is the jurisdictional authority of the arbitration branch of the NLRC. The employer-employee relationship is only incidental, and the cause of action arises from other sources like torts and damages. Therefore, jurisdiction belongs to the regular courts. Natasha Shoe Company adopted an organizational streamlining program that resulted in the retrenchment of 550 employees in its main plant. After having been paid their separation benefits, the retrenched workers demanded payment of retirement benefits under a CBA between their union and management. Natasha Shoe Company denied the workers' demand. What is the most procedurally peaceful means to resolve this dispute? Answer. Since this is a money claim involving the interpretation and implementation of the CBA, the retrenched workers can refer the matter to the grievance machinery, and if it remained unresolved within 7 days from the date of its submission, the same shall be automatically referred to the voluntary arbitration prescribed in the CBA. In the alternative, it can be argued that since this is a dispute between the retrenched workers and the employer, the same cannot be a subject matter of grievance and voluntary arbitration. This is because only disputes between the union and the company, as ruled in Tabique versus International Copra Export Corporation, GR 183335, December 23, 2009, shall be referred to grievance machinery or voluntary arbitrators. Thus, the dispute should be resolved by way of mandatory conciliation mediation in accordance with Article 234 of the Labor Code. Letter B. Can the workers claim both separation pay and retirement benefits? Yes, the workers can claim both separations pay and retirement benefits. This was settled rule in the case of Goodyear versus Marina Angus, GR 185499, 2014, where it was ruled that in the absence of an express or implied prohibition against it, collection of both retirement benefits and separation pay upon severance from employment is allowed. This is grounded on the social justice policy that doubt should always be resolved in favor of labor rights. Aquino versus National Labor Relations, February 11, 1992. Nelda worked as a chambermaid in Hotel Neverland with a basic wage of 560 pesos for an 8-hour workday. On Good Friday, she worked for 1 hour from 10 p.m. to 11 p.m. Her employer paid her only 480 for each 8-hour workday and 70 pesos for work done on Good Friday. She sued for underpayment of wages and non-payment of holiday pay and night shift differential for working on a Good Friday. Hotel Neverland denied the alleged underpayment, arguing that based on long-standing unwritten tradition, food and lodging costs were partially shouldered by the employer and partially paid for by the employee through salary deduction. According to the employer, such valid deduction caused the payment of Nelda's wage to be below the prescribed minimum wage. The hotel also claimed that she was not entitled to holiday pay and night shift differential pay. Hotel workers have to work on holidays and may be assigned to work at night. Does the hotel have valid legal grounds to deduct food and lodging costs from Nelda's basic salary? As held in Mabisa versus National Labor Relations Commission, GR 118506, 1997, granting that meals and lodging were provided and indeed constituted facilities, such facilities could not be deducted without employer complying first with certain legal requirements. Without satisfying these requirements, the employer simply cannot deduct the value from the employee's wages. First, proof must be shown that such facilities are customarily furnished by the trade. Second, the provision of deductible facilities must be voluntarily accepted in writing by the employee. Finally, facilities must be charged at fair and reasonable value. Labor Code, Article 97, letter F. Applying the above, unless the hotel can comply with the legal requirements, it has no valid legal grounds to deduct food and lodging costs from Nelda's basis salary. B. Applying labor standards law. How much should Nelda be paid for work done on Good Friday? Show the computation in your test booklet and encircle your final answer. Suggested answer. It can be argued. The rule in order to be paid regular holiday, like 2 successive holidays, provides as follows. Where there are 2 successive regular holidays, like Holy Thursday and Good Friday, an employee may not be paid for both holidays if he absents himself from work on the day immediately preceding the first holiday, unless he works on the first holiday, in which case he is entitled to his holiday pay on the second holiday. Section 10, Rule 4, Book 3, Rules to implement the Labor Code. Applying the above rule, unless Nelda had complied with the rules on absences, she is not entitled for holiday pay for work done on Good Friday. However, on the assumption that she complied with the rules, Nelda should be paid as follows. 560 times 200% equals 1,120 pesos. Or since she only worked for 1 hour, the pay should be as follows. 70 times 200% equals 140 pesos. A certification election was conducted in Nation Manufacturing Corporation, whereby 55% of eligible voters in the bargaining unit cast their votes. The results were as follows. Union Nana, 45 votes. Union Nada, 40 votes. Union Nada, 30 votes. No Union, 80 votes. Union Nana moved to be declared as the winner of the certification election. Can Union Nana be declared as the winner? Suggested answer: Union Nana cannot be declared as the winner. This is because the said union did not obtain the majority of the valid votes cast as provided under Article 268 of the Labor Code. Letter B. Assume that the eligibility of 30 voters was challenged during pre-election conference. The ballots of the 30 challenged voters were placed inside an envelope sealed by the Dole election office. Considering the said envelope remains sealed, what should be the next course of action with respect to the said challenged votes? The procedure in a challenge of votes provides as follows. The ballot of the voter who has been properly challenged during the pre-election conferences shall be placed in an envelope which shall be sealed by the election officer in the presence of the voter and the representatives of the contending unions. The election officer shall indicate on the envelope the voter's name, the union challenging the voter, and the ground for the challenge. The sealed envelope shall then be signed by the election officer and the representatives of the contending unions. The election officer shall note all challenges in the minutes of the election proceedings and shall have custody of all envelopes containing the challenged votes. The envelopes shall be opened and the question of eligibility shall be passed upon by the mediator arbiter only if the number of segregated votes will materially alter the result of the election. Section 11, Rule 9, Book 5, Rules to Implement the Labor Code, as amended by Department Order 40 F03, Series of 2008, and renumbered by Department Order 4115, Series of 2015. Applying the said procedure, if the number of segregated votes will materially alter the result of the election, the next course of action with respect to the said challenged votes is to open the said envelopes, and the question of eligibility shall be passed upon by the mediator arbiter. NICO is a medical representative engaged in the promotion of pharmaceutical products and medical devices for North Pharmaceuticals, Inc. He regularly visits physicians' clinics to inform them of the chemical composition and benefits of his employer's products. At the end of every day, he receives a basis wage of 700 pesos plus 150 productivity allowance. For purposes of computing NICO's 13-month pay, should the daily productivity allowance be included? For purposes of computing NICO's 13-month pay, his daily productivity allowance cannot be included. In Philippine Spring Waters Resources versus Court of Appeals, June 11, 2004, clarified as to when a commission forms part of basic salary to be considered in the computation of 13-month pay. The High Court said it is well established in jurisprudence that the determination of whether or not a commission forms part of the basic salary depends upon the circumstances or conditions for its payment. In Philippine Duplicators, Inc. versus NLRC, November 11, 1993, the court held that commissions earned by salesmen form part of their basic salary. The salesman's commissions, comprising a predetermined percentage of the selling price of the goods sold by each salesman, were properly included in the term basic salary for purposes of computing the 13-month pay. The salesman's commissions are not overtime payment, nor profit-sharing payments, nor any other fringe benefit, but a portion of the salary structure which represents an automatic increment to the monetary value initially assigned to each unit of work rendered by a salesman. On the other hand, in Boy Takeda Chemicals versus De La Serna, December 10, 1993, the so-called commissions paid to or received by medical representatives were excluded from the term basic salary because these were paid to the medical representatives and rank-and-file employees as productivity bonuses, which were generally tied to the productivity or capacity for revenue production of a corporation, and such bonuses closely resemble profit-sharing payments and had no clear direct or necessary relation to the amount of work actually done by each individual employee. Applying the above rule, the productivity allowance cannot be included. Note: Question involving the same subject matter was given during the 2011 bar examination. An alternative answer can be given by stating that it will depend as to whether the productivity bonus forms part of the salary. In fine, whether or not the productivity bonus forms part of the basic salary depends upon the circumstances or conditions for its payment, which indubitably are factual in nature. If the productivity bonuses were because they were generally tied to the productivity or capacity for revenue production, it will not form part of the salary. However, if it has a clear direct or necessary relation to the amount of work actually done by each individual employee, then it forms part of the salary. This was the distinction given by the case of Reyes versus NLRC, August 8, 2007, citing the cases of field duplicators versus NLRC, November 11, 1993, and monetary value initially assigned to each unit of work rendered by a salesman. On the other hand, in Boei Takeda Chemicals versus De La Cruz, numbers 92174 and 102552, December 10, 1993. Question number 8. Nathaniel has been a salesman assigned by Newmark Enterprises, or Newmark, for nearly 2 years at the Manila office of Nutrition City. He was deployed pursuant to a service agreement between Newmark and Nutrition City, the salient provisions of which were as follows. A. The contractor, Newmark, agrees to perform and provide the client, Nutrition City, on a non-exclusive basis such tasks or activities that are considered contractable under existing laws as may be needed by the client from time to time. Letter B. The contractor shall employ the necessary personnel like helpers, salesmen, and drivers who are determined by the contractor to be efficiently trained. Letter C. The client may request replacement of the contractor's personnel if quality of the desired result is not achieved. Letter D. The contractor's personnel will comply with the client's policies, rules, and regulations. And letter E. The contractor's 2 service vehicles and necessary equipment will be utilized in carrying out the provisions of this agreement. When Newmark fired Nathaniel, he filed an illegal dismissal case against the wealthier company, Nutrition City, alleging that he was a regular employee of the same. Is Nathaniel correct? Nathaniel is correct insofar as the existence of employer-employee relationship between him and the principal. The rules require that the service agreement between the principal and the contractor shall include the following. 1. The specific description of the job or work being subcontracted, including its term or duration. Number 2. The place of work and terms and conditions governing the contracting arrangement, to include the agreed amount of the contracted job or work, as well as the standard administrative fee of not less than 10% of the total contract cost. And 3. A provision on the issuance of the bond or bonds defined under Section 3, letter A, renewable every year, Section 11, DO, number 174, series of 2017. On the other hand, a finding of violation of 11 shall render the principal the direct employer of the employees of the contractor or subcontractor pursuant to Article 109 of the Labor Code as amended, Section 12, DO, number 174, series of 2017. Applying the above rules, since Newmark and Nutrition City violated the required terms to be stated in the service agreement, then Nutrition City is the direct employer of Nathaniel. As to whether Nathaniel is a regular employee of Nutrition City, the rules are as follows. Regular employees are further classified into 1. Regular employees by nature of work, and 2. Regular employees by years of service. E. Gunson versus National Labor Relations. The former refers to those employees who perform a particular activity which is necessarily or desirable in the usual business or trade of the employer, regardless of their length of service, while the latter refers to those employees who have been performing the job, regardless of the nature thereof, or at least for a year. Pangilinan versus General Milling Corporation. Tested from the nature of his work and the activity of the principal, Nathaniel could be a regular employee, while if it is tested on the length of service, then Nathaniel is a regular employee, as he has been employed with the principal for at least a year. In fact, he was employed for nearly 2 years. Sergeant Nemesis was a detachment non-commissioned officer of the Armed Forces of the Philippines in Nueva Ecija. He and some other members of his detachment sought permission from their company commander for an overnight pass to Nueva Vizcaya to settle some important matters. The company commander orally approved their request and allowed them to carry their firearms, as the place they were going to was classified as a critical place. They arrived at the place past midnight, and as they were alighting from a tricycle, one of his companions accidentally dropped his rifle, which fired a single shot, and in the process hit Sergeant Nemesis fatally. The shooting was purely accidental. At the time of his death, he was still legally married to Nelda, but had been separated de facto from her for 17 years. For the last 15 years of his life, he was living with Narda, with whom he has 2 minor children. Since Narda works as a kasambahay, the 2 children lived with their grandparents, who provided their daily support. Sergeant Nemesis and Narda only sent money to them every year for their school tuition. Nelda and Narda, both for themselves, and the latter also on behalf of her minor children, separately filed claims for compensation as a result of the death of Sergeant Nemesis. The Line of Duty Board of the AFP declared Sergeant Nemesis' death to have been in line of duty and recommended that all benefits due to Sergeant Nemesis be given to his dependents. However, the claims were denied by GSIS because Sergeant Nemesis was not in his workplace nor performing his duty as a soldier of the Philippine Army when he died. Are the dependents of Sergeant Nemesis entitled to compensation as a result of his death? The death of Sergeant Nemesis is compensable because it is work-connected. However, insofar as entitlement of the dependents of Sergeant Nemesis for compensation as a result of his death, the dependent spouse cannot claim compensation. The law requires that the dependent spouse should be a legitimate spouse living with the employee. Article 173, Labor Code. In this case, the legitimate spouse Nelda is not entitled because she is not living with Sergeant Nemesis, while Narda will not qualify as dependent spouse as she is not a legitimate spouse of Sergeant Nemesis, although she is living with the latter. On the other hand, insofar as the dependent child, the law requires that the dependent child be legitimated, legally adopted, or who is unmarried, not gainfully employed, not over 21 years old, provided he is incapacitated and incapable of self-support due to physical or mental defect, which is congenital or acquired during minority. The 2 minor children are therefore qualified as dependent children, hence entitled to compensation. As between Nelda and Narda, who should be entitled to the benefits? Nelda and Narda are not entitled to the benefits because they failed to qualify within the definition of Article 173, Labor Code, as dependent spouse. Question 10. Donato had been continuously employed and deployed as a seaman who performed services that were necessary and desirable to the business of Entrain Shipping through its local agent, Narita Maritime Services Agency, in accordance with the 210 or 2010 Philippine Overseas Employment Administration Standard Employment Contract or 210 POEA SEC. Donato's last contract for 12 months expired on November 15, 2016. Donato was then repatriated due to finished contract. He immediately reported to the agency and complained that he had been experiencing dizziness, weakness, and difficulty in breathing. The agency referred him to Dr. Neri, who examined, treated, and prescribed him with medications. After a few months of treatment and consultations, Donato was declared fit to resume work as a seaman. Donato went back to the agency to ask for redeployment, but the agency rejected his application. Donato filed an illegal dismissal case against the agency and its principal, with a claim for total disability benefits based on the ailments that he developed on board and trained shipping vessel. The claim was based on the certification of his own physician, Dr. Nunez, that he was unfit for sea duties because of his hypertension and diabetes. Was Nonato a regular employee of Entrain Shipping? Nonato is not regular employee of Entrain Shipping. The fact that seafarers are not regular employees is already a settled rule. In Petroleum Shipping Limited, formerly also ESSA International Shipping, the Supreme Court said that the issue on whether seafarers are regular employees is already a settled matter. Thus, the High Court said. It was in Ravago, Esso, Eastern Maritime, in March 2005, where the Honorable Supreme Court traced its ruling in a number of cases that seafarers are contractual, not regular employees. Thus, in Brent School versus Zamora, the Supreme Court cited overseas employment contract as an example of contracts where the concept of regular employment does not apply, whatever the nature of the engagement and despite the provisions of Article 280 of the Labor Code. The Supreme Court held that the agency is liable for payment as a seaman's medical and disability benefits in the event that the principal fails to refuse to pay the benefits or wage to the seaman, although the seaman may not be a regular employee of the agency. The Supreme Court squarely passed upon the issue in Milares versus NLRC, where one of the issues raised was whether seafarers are regular or contractual employees whose employment are terminated every time their contracts of employment expire. The Supreme Court explained, it is clear that seafarers are considered contractual employees. They cannot be considered as regular employees under Article 280 of the Labor Code. Their employment is governed by the contracts they sign every time they are rehired, and their employment is terminated when the contract expires. Their employment is contractually fixed for a certain period of time. They fall under the exception of Article 280, whose employment has been fixed for a specific project or undertaking, the completion of or termination of which has been determined at the time of engagement of the employee, or where the work or service ceased to be performed is seasonal in nature, and the employment is for the duration of the season. We need not depart from rulings of the court in the two aforementioned cases, which indeed constitute stare decisis with respect to the employment status of seafarers. Can Nonato successfully claim disability benefits against Entrain Shipping and its agent Narita Maritime Services? The claim for disability benefits of Nonato against Entrain Shipping and its agent Narita Maritime Services will not prosper for prematurity. The Supreme Court laid down the procedures for filing disability benefits and its effect in case of failure to comply with the procedures in Daruwag versus KGJS Fleet Management Manila, 2015. Thus, in denying the claim for disability benefits due to prematurity, the Supreme Court ruled, petitioner did not comply with the procedures. In Vergara versus Hamunia Maritime Services, it was stated that the Department of Labor and Employment, through the POEA, has simplified the determination of liability for work-related death, illness, or injury in the case of Filipino seamen working on foreign ocean-going vessels. Every seaman and the vessel owner, directly or represented by a local manning agency, are required to execute the POEA standard employment contract as a condition sine qua non prior to the deployment of the seaman for overseas work. The POEA SEC is supplemented by the Collective Bargaining Agreement, CBA, between the owner of the vessel and the covered seaman. In this case, the parties entered into a contract of employment in accordance with the POEA SEC, and they agreed to be bound by the CBA. Thus, in resolving petitioner's claim for disability compensation, the court will be guided by the procedures laid out in the POEA SEC and in the CBA. On this point, Section 20, letter B, number 3 of the POEA SEC provides, upon sign-off from the vessel for medical treatment, the seafarer is entitled to sickness allowance equivalent to his basic wage until he is declared fit to work, or the degree of permanent disability has been assessed by the company-designated physician, but in no case shall this period exceed 120 days. For this purpose, the seafarer shall submit himself to a post-employment medical examination by a company-designated physician within 3 working days upon his return, except when he is physically incapacitated to do so, in which case a written notice to the agency within the same period is deemed a compliance. Failure of the seafarer to comply with the mandatory reporting requirement shall result in his forfeiture of the right to claim the above benefits. If a doctor appointed by the seafarer disagrees with the assessment, a third doctor may be agreed jointly between the employer and the seafarer. The third doctor's decision shall be final and binding on both parties. Question 11. Your favorite relative, Tita Nilda, approaches you and seeks your advice on her treatment of her kasambahay, Naray. Tita Nilda shows you a document called a contract of engagement for your review. Under the contract of engagement, Noray shall be entitled to a rest day every week, provided that she may be requested to work on a rest day if Tita Nilda should need her services that day. Tita Nilda also claims that this contract of engagement should embody the terms and conditions of Noray work, as the engagement of a kasambahay is a private matter and should not be regulated by the state. Is Tita Nilda correct in saying that this is a private matter and should not be regulated by the state? Tita Nilda is not correct in saying that engagement of a kasambahay is a private matter and should not be regulated by the state. This is a valid subject because of the exercise of police power to give effect to the declared policy of the law, such as the need to protect the rights of domestic workers against abuse, harassment, violence, economic exploitation, and performance of work that is hazardous to their physical and mental health, and in protecting domestic workers and recognizing their special needs to ensure safe and healthful working conditions, promotes gender-sensitive measures, and the formulation and implementation of policies and programs affecting the local domestic work. Section 2, Article 1, Republic Act 10361. Is the stipulation that she may be requested to work on a rest day legal? The stipulation that Noray may be requested to work on a rest day is legal. The law provides that nothing in this provision shall deprive the domestic worker and the employer from agreeing to the following: A. Of setting a day of absence with a particular rest day. B. Waiving a particular rest day in return for an equivalent daily rate of pay. C. Accumulating rest days not exceeding 5 days, or other similar arrangements. Are stay-in family drivers included under the Kasambahay law? Stay-in family drivers are not included under the Kasambahay law. This was very clear in the rules implementing the Kasambahay law, providing as follows: the following are not covered: A. Service providers. B. Family drivers. C. Children under foster family arrangement. And D. Any other person who performs work occasionally or sporadically and not on an occupational basis. Section 2, Rule 1, Implementing Rules and Regulations of Republic Act 10361. Question 12. Nena worked as an executive assistant for Nesting, CEO of the Now Corporation. One day, Nesting called Nena into his office and showed her lewd pictures of women in seductive poses, which Nena found offensive. Nena complained before the general manager, who in turn investigated the matter and recommended the dismissal of Nesting to the board of directors. Before the board of directors, Nesting argued that since the anti-sexual harassment law requires the existence of sexual favors, he should not be dismissed from the service since he did not ask for any sexual favor from Nena. Is Nesting correct? Nesting is not correct. The law penalizes sexual harassment in our jurisdiction in RA 7877. Section 3 thereof defines work-related sexual harassment in this wise. Section 3. Work, education, or training-related sexual harassment defined. Work, education, or training-related sexual harassment is committed by an employer, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of said act. In a work-related or employment environment, sexual harassment is committed when 3. The above acts would result in an intimidating, hostile, or offensive environment for the employee. Contrary to Nesting's claim, it is enough that his acts result in creating an intimidating, hostile, or offensive environment for the employee. Question 13. Nicodemus was employed as a computer programmer by Network Corporation, a telecommunications firm. He has been coming to work in shorts and sneakers in violation of the prescribed uniform policy based on company rules and regulations. The company human resources manager wrote him a letter giving him 10 days to comply with the company uniform policy. Nicodemus asserted that wearing shorts and sneakers made him more productive and cited his above-average output. When he came to work still in violation of the uniform policy, the company sent him a letter of termination of employment. Nicodemus filed an illegal dismissal case. The labor arbiter ruled in favor of Nicodemus and ordered his reinstatement with back wages. Network Corporation, however, refused to reinstate him. The NLRC First Division sustained the labor arbiter's judgment. Network Corporation still refused to reinstate Nicodemus. Eventually, the Court of Appeals reversed the decision of the NLRC and ruled that the dismissal was valid. Despite the reversal, Nicodemus still filed a motion for execution with respect to his accrual. Back wages. Were there valid legal grounds to dismiss Nicodemus from his employment? Yes. Nicodemus can be dismissed based on willful disobedience to the lawful order under Article 297 of the Labor Code and the prescribed uniform policy of the company. The basis is the case of St. Luke's versus Sanchez, March 11, 2015, where it was ruled at the same time the employee has a corollary duty to obey all reasonable rules, orders, and instruction of the employer, and willful or intentional disobedience thereto, as a general rule, justifies termination of the contract of service and the dismissal of the employee. Malabago versus NLRC. Note that for an employee to be validly dismissed on this ground, the employer's orders, regulations, or instructions must be 1. Reasonable and lawful, 2. Sufficiently known to the employee, and 3. In connection with the duties which the employee has been engaged to discharge. Should Nicodemus' motion for execution be granted? Yes. Nicodemus' motion for execution should be granted. He is entitled to his accrued salary. The accrued wages of salaries, reinstatement wages, salary is the consequence of the reinstatement aspect of the decision of the labor arbiter referred in paragraph 3, Article 229 of the Labor Code. This means that a dismissed employee whose case was favorably decided by the labor arbiter is entitled to receive wages pending appeal upon reinstatement, which is immediately executory. In other words, it refers to the wages or salaries which automatically accrued to a dismissed employee from the notice of the labor arbiter's order or reinstatement until it's ultimately reversed by the higher court, which could be the NLRC, the Court of Appeals, or the Supreme Court. The entitlement to accrued wages or salaries or reinstatement wages or salaries of a dismissed employee was discussed in the case of Roquero versus Philippine Airlines. In resolving the rule on entitlement to accrued wages between the period where the labor arbiter's order of reinstatement is pending appeal and the NLRC resolution overturning that of the labor arbiter, the case of Garcia versus Philippine Airlines, January 20, 2009, is in point. The Supreme Court examined its conflicting rulings with respect to the application of paragraph 3, Article 223 of the Labor Code. The core of the seeming divergence is the application of paragraph 3 of Article 223 of the Labor Code, which reads, "In any event, the decision of the labor arbiter reinstating a dismissed or separated employee, and so far as the reinstatement aspect is concerned, shall immediately be executory, pending appeal." The employee shall either be admitted back to work unless the same terms and conditions prevailing prior to his dismissal or separation, or at the option of the employer, merely reinstated in the payroll. The posting of a bond by the employer shall not stay the execution for reinstatement provided herein. The view, as maintained in a number of cases, is that even if the order of reinstatement of the labor arbiter is reversed on appeal, it is obligatory on the part of the employer to reinstate and pay the wages of the dismissed employee during the period of appeal until reversal by the higher court. On the other hand, if the employee has been reinstated during the appeal period and such reinstatement order is reversed with finality, the employee is not required to reimburse whatever salary he received, for he is entitled to such. More so if he actually rendered services during the period. In other words, a dismissed employee whose case was favorably decided by the labor arbiter is entitled to receive wages pending appeal upon reinstatement, which is immediately executory. Unless there is a restraining order, it is ministerial upon the labor arbiter to implement the order of reinstatement, and it is mandatory on the employer to comply therewith. Question 14. Nelson complained before the Dole Regional Office about Needy Corporation's failure to pay his wage increase amounting to $5,000 as mandated in a wage order issued by the Regional Tripartite Wage and Productivity Board. Consequently, Nelson asked the Dole to immediately issue an order sustaining his money claim. To his surprise, he received a notice from the Dole to appear before the regional director for purposes of conciliating the dispute between him and Needy Corporation. When conciliation before the regional director, the latter proceeded to direct both parties to submit their respective position paper in relation to the dispute. Needy Corporation argued that since Nelson was willing to settle for 75% of his money claim during conciliation proceedings, only a maximum of 75% of the said money claim may be awarded to him. Was Dole's action to conduct mandatory conciliation in light of Nelson's complaint valid? Yes, the Dole's action to conduct mandatory conciliation is valid. This is mandated by Article 234 of the Labor Code, except as provided in Title 7, Letter A, Book 5 of this code, as amended, or as may be exempted by the Secretary of Labor and Employment. All issues arising from labor and employment shall be subject to mandatory conciliation mediation. Should the regional director sustain Needy Corporation's argument, the regional director should not sustain Needy Corporation's argument. This is because under Article 239 of the Labor Code, information and statements made at conciliation proceedings shall be treated as privileged communication and shall not be used as evidence in the commission. Conciliators and similar officials shall not testify in any court or body regarding any matters taken up at conciliation proceedings conducted by them. Thus, Needy Corporation cannot raise the argument that Nelson was willing to settle for 75% of his money claim during conciliation proceedings. Question 15. Next turn, Corporation employed Nini and Nono, whose tasks involved directing and supervising rank and file employees engaged in company operations. Nini and Nono are required to ensure that such employees obey company rules and regulations and recommend to the company's Human Resources Department any required disciplinary action against erring employees. In Next Turn Corporation, there are indeed independent unions representing rank and file and supervisory employees, respectively. May Nini and Nono join a union? Yes, Nini and Nono can join a union. This is clearly allowed under Article 255 of the Labor Code, which provides in substance that supervisory employees may join, assist, or form separate collective bargaining units and or legitimate labor organizations of their own. B. May the two unions be affiliated with the same union federation? Yes, the two unions can be affiliated with the same union federation. This is clearly allowed under Article 255 of the Labor Code, which provides in substance that the rank and file union and the supervisors union operating within the same establishment may join the same federation or national union. Question 16. NAGRUB Union and NAGRUB Corporation have been existing CBA, which contains the following provision. New employees within the coverage of the bargaining unit who may be regularly employed shall become members of NAGRUB Union. Membership in good standing with the NAGRUB Union is a requirement for continued employment with NAGRUB Corporation. NAGRUB Corporation consequently acquired all the assets and rights of NUBER Corporation and absorbed all of their latter's employees. NAGRUB Union immediately demanded enforcement of the above-stated CBA provision with respect to the absorbed employees. NAGRUB Corporation refused on the ground that this should not apply for the absorbed employees who were former employees of another corporation whose assets and right it had acquired. Letter A. Was NAGRUB Corporation correct in refusing to enforce the CBA for provision with respect to the absorbed employees? NAGRUB Corporation was not correct in refusing to enforce the CBA provision with respect to the absorbed employees. This is because it cannot invoke its merger with another corporation as a valid ground to exempt its absorbed employees from the coverage of a union shop clause contained in its existing collective bargaining agreement with its own certified labor union. In Bank of the Philippine Islands versus BPI Employees, Union Davao, Chapter Federation of Unions in BPI Unibank, August 10, 2010, the High Court resolved the question in this matter. At the onset, we should call to mind the spirit and the letter of the Labor Code provisions in Union Security Clauses, specifically Article 248, letter E, which states, "Nothing in this code or in any other law shall stop the parties from requiring membership in a recognized collective bargaining agent as a condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining agreement." This case, which involves the application of a collective bargaining agreement with a union shop clause, should be resolved principally from the standpoint of the clear provision of our labor laws and the express terms of the CBA in question, and not by inference from the general consequence of the merger of corporations under the Corporation Code, which obviously does not deal with and therefore is silent on the terms and conditions of employment in corporations or juridical entities. May a newly regularized employee of NAGRUB Corporation who is not part of the absorbed employee is refused to join NAGRUB Union, how would you advise the human resource manager of NAGRUB Corporation to proceed? The newly regularized employee of NAGRUB Corporation who is not part of the absorbed employees cannot refuse to join NAGRUB Union in view of the Union Security Clause provision of the CBA. While the right to join includes the right not to join, however, the exception is the Union Security Clause, where it imposes upon employees the obligation to acquire or retain union membership as a condition affecting employment. Thus, I will advise the human resource manager of NAGRUB Corporation to comply with the provision of the CBA, stating that new employees within the coverage of the bargaining unit who may be regularly employed shall become member of NAGRUB Union. Question 17. Upon compliance with the legal requirements of the conduct of a strike, Nevada Union staged a strike against Newfound Corporation on account of a collective bargaining deadlock. During the strike, some members of Nevada Union broke the windows and punctured the tires of the company-owned buses. The Secretary of Labor and Employment assumed jurisdiction over the dispute. Should all striking employees be admitted back to work upon the assumption of jurisdiction by the Secretary of Labor and Employment? Will these include striking employees who damaged company properties? All striking employees be admitted back to work, and including striking employees who damaged company properties. The effect of assumption of jurisdiction of the Secretary of Labor is clear under Article 278, letter G, which provides in substance that such assumption shall have the effect of automatically enjoining the intended or impending strike or lockout as specified in the assumption or certification order. If one has already taken place at the time of assumption or certification, all striking or locked out employees shall immediately return to work, and the employer shall immediately resume operations and readmit all workers under the same terms and conditions prevailing before the strike or lockout. May the company readmit strikers only by restoring them to the payroll? The company may not readmit strikers by restoring them to the payroll. The phrase under the same terms and conditions found in Article 278 letter G, 263 letter G of the Labor Code was interpreted by the Supreme Court in the case of the University Immaculate Conception versus Secretary of Labor as follows. With respect to the Secretary's order allowing payroll reinstatement instead of actual reinstatement, for the individual respondents herein, an amendment to the previous orders issued by her office, the same is usually not allowed. Article 263 letter G of the Labor Code aforementioned states that all workers must immediately return to work and all employers must readmit all of them under the same terms and conditions prevailing before the strike or lockout. The phrase under the same terms and conditions makes it clear that the norm is actual reinstatement. This is consistent with the idea that any work stoppage or slowdown in that particular industry can be detrimental to the national interest. Clearly, reinstatement should be actual and not payroll reinstatement. Question 18. Nestor and Nadine have been living in for the last 10 years without the benefit of marriage. Their union has produced 4 children. Nadine was 3 months pregnant with her 5th child when Nestor left her for another woman. When Nadine was 8 months pregnant with her 5th child, she applied for maternity leave benefits. Her employer refused on the ground that his was already her 5th pregnancy and that she was only living in with the father of her child, who is now in a relationship with another woman. When Nadine gave birth, Nestor applied for paternity leave benefits. His employer also denied the application on the same grounds that Nadine's employer denied her application. Can Nadine's employer legally deny her claim for maternity benefit? Yes, Nadine's employer can legally deny her claim for maternity benefits. This is because the maternity benefits shall be paid only for the first 4 deliveries or miscarriages. See Section 14-A, RA 8282. In this case, the said pregnancy was the 5th child of Nadine, thus she already exhausted the limitations for entitlement to maternity benefits under the law. Can Nestor's employer legally deny his claim for paternity benefits? Nestor's employer can legally deny his claim for paternity benefits for his failure to comply with the conditions for entitlement to paternity benefits. A. He is an employee at the time of delivery of his child. B. He is cohabiting with his spouse at the time she gives birth or suffers a miscarriage. C. She has applied for paternity leave in accordance with Section 4 hereof. And D. His wife has given birth or suffered a miscarriage. Section 3 Revised Implementing Rules and Regulations of Republic Act 8187 of the Private Sector. In this case, Nadine is not Nestor's lawful wife to whom he is cohabiting. Question 19. Northeast Airlines sent notices to transfer without diminution in salary or rank to 50 ground crew personnel who were frontliners at Northeast Airline counters at the Ninoy Aquino International Airport. The 50 employees were informed that they would be distributed to various airports in Mindanao to anticipate robust passengers volume growth in the area. Northeast Union, representing rank-and-file employees, filed unfair labor practice and illegal dismissal cases before the NLRC, citing among others the inconvenience of the 50 concerned employees and union discrimination. As 8 of the 50 concerned ground crews personnel were union officers. Also, the union argued that Northeast Airlines could easily hire additional employees from Mindanao to boost ground operations in the Mindanao airport. Will the transfer of the 50 ground crew personnel amount to legal dismissal? The transfer of the 50 ground crew personnel does not amount to legal dismissal. This is because their transfer is a valid exercise of management prerogatives. In Jemima Jr. versus Bankwise, October 23, 2013, it was held the employer's right to conduct the affairs of his business according to his discretion and judgment is well recognized. An employer has a free rein and enjoys wide latitude of discretion to regulate all aspects of employment, and the only criterion to guide the exercise of its management prerogative is that the policies, rules, and regulations on work-related activities on the employees must always be fair and reasonable. The Coca-Cola Export Corporation versus Gakayan. According to Endico versus Quantum Foods Distribution Center, managerial prerogatives, however, are subject to limitations provided by law, collective bargaining agreement, and general principles of fair play and justice. The test for determining the validity of the transfer of employees was explained in the case of Blue Diary Corporation versus NLRC. The Supreme Court explained the test of determining the validity of the transfer of employees as follows. But like other rights, there are limits thereto. The managerial prerogative to transfer personnel must be exercised without grave abuse of discretion, bearing in mind the basic element of justice and fair play. Having the right should not be confused with the manner in which that right is exercised. Thus, it cannot be used as a subterfuge by the employer to rid himself of an undesirable worker. In particular, the employer must be able to show that the transfer is not unreasonable, inconvenient, or prejudicial to the employee, nor does it involve a demotion in rank or a diminution of his salaries, privileges, and other benefits. As their employer, Northeast Airlines has the right to regulate, according to its discretion and best judgment, work assignments, work methods, work supervision, and work regulations, including the hiring, firing, and discipline of its employees. The Supreme Court upholds this management prerogative so long as they are exercised in good faith for the advancement of the employer's interests and not for the purpose of defeating or circumventing the rights of the employees under special laws and valid agreements. Challenge Sox Corporation versus Court of Appeals. In this case, it does not show that Northeast Airlines implemented the transfer for the purpose of defeating or circumventing the right of the said 50 ground crew personnel. Will the unfair labor practice case prosper? The unfair labor practice case will not prosper. This is because the act did not constitute an act of interfering, restraining, or coercing the said employees in the exercise of their right to self-organization under Article 259. In TNT Shoplifters Corporation or Gene Queen Corporation versus TNT Shoplifters Corporation, Workers Union, citing the case of Insular Life Assurance, Employees Association NATO versus Insular Life Assurance, the Supreme Court had occasion to lay down the test of whether an employer has interfered with and coerced employees in the exercise of their right to self-organization. That is, whether the employer has engaged in conduct which it may reasonably be said tends to interfere with the free exercise of employees' right, and that it is not necessary that there be direct evidence that any employee was in fact intimidated or coerced by statements of threats of the employer if there is a reasonable inference that anti-union conduct of the employer does have an adverse effect on self-organization and collective bargaining. In the given facts, it does not show that the act of Northern Airlines in sending notices to transfer relates to the commission of acts that transgress the right to organize, or it was made to interfere, restrain, or coerce them with the exercise of their right to self-organization. Question 20. In Northern Lights Corporation, union members NAD, NED, and NOD sought permission from the company to distribute flyers with respect to a weekend union activity. The company HR manager granted the request through a text message sent to another union member, Norlene, while NAD, NED, and NOD redistributing the flyers at the company assembly plant. A company supervisor barged in and demanded that they cease from distributing the flyers, stating that the assembly line employees were trying to beat a production deadline and were thoroughly distracted. Norlin tried to show the HR manager's text message authorizing flyer distribution during work hours, but the supervisor brushed it aside. As a result, Nat, Ned, and Nod were suspended for violating company rules and trespass in highly limited union activities during work hours. The union filed an unfair labor practice case before the NLRC for union discrimination. Will the ULP case filed by the union prosper? The ULP case filed by the union will not prosper. This is because the act did not constitute an act of interfering, restraining, or coercing the said employees in the exercise of their right to self-organization under Article 259, letter A of the Labor Code. In TNT Shoplifters Corporation versus TNT Shoplifters Corporation Workers Union, citing the case of Insular Life Assurance versus Insular Life Assurance Company, the Supreme Court had occasion to lay down the test of whether an employer has interfered with and coerced employees in the exercise of their right to self-organization. That is, whether the employer has engaged in conduct which, it may reasonably be said, tend or interfere with the free exercise of employees' right, and that is not necessary that there be direct evidence that any employee was in fact intimidated or coerced by statement of threats of the employer if there is a reasonable inference that anti-union conduct of the employer does have an adverse effect on self-organization and collective bargaining. In the given facts, it does not show that the act of the company supervisor in barging in and demanding for Nad, Ned, and Nod to cease from distributing the flyers relates to the commission of acts that transgress their right to organize, or it was made to interfere, restrain, or coerce them with the exercise of their right to self-organization. Assume the NLRC ruled in favor of the union. The labor arbiter's judgment included, among others, an award for moral and exemplary damages at $50,000 each for Nad, Ned, and Nod. Northern Lights Corporation argued that any award damage should be given to the union and not individually to its members. Is Northern Lights Corporation correct? Northern Lights Corporation is not correct. The rights they were violated belongs to the union members, Nad, Ned, and Nod, and not the union itself. Further, the said union members were the real party in interest in the said case, for ULP filed by the union against the corporation and not the union itself. The union is a juridical person, and as a rule, it cannot suffer moral damages.